Constitutional Law, Fali Nariman joins me. Appreciate your joining me, Mr. Nariman. I want to start with this fierce debate over whether this judgment undermines federal principles or does it strengthen national integration. What's your view?
Well, before I come to that, Rajdeep, permit me just to say this.
Yes.
That before the judgment came, and before perhaps it was argued, because I didn't follow the argument too much, my own view was that the presidential power under 370, clause 3, could not be exercised at all in the manner in which it was done. And for this reason, that as you know, there is an article, supervening article in the Constitution which says amendment of the Constitution. And it expressly states that each and every provision of the Constitution can be amended. Therefore, we have to judge the validity of what happened in August of 2019 by reference to that event. In Article 368, as you say, as I said, says each and every provision can be amended. It includes a temporary provision, it includes a permanent provision. And the manner in which it has to be done is that it has to go before two houses of parliament, get the requisite majority, and thereafter get the presidential assent. There is no other manner. But, and there's a big but, in 370 there is a subclause 4 which expressly states that the president is empowered also to revoke the status of a temporary inclusion in the Constitution. But it is conditioned. It says he can only do this, and you must see the proviso.
Yes.
You can only do this, that the recommendation of the Constituent Assembly of the state of J&K is necessary before the President issues such a notification. Now, admittedly, there could not be such a notification for the simple reason that there was no Constituent Assembly in existence.
Yes.
And secondly, that the Constitution of J&K itself had been abrogated. So this was otiose. But you cannot say that a proviso is otiose, for God's sake.
Otiose meaning is infructuous,
infructuous, ineffective.
Yeah, because you see, the Supreme Court judgment
yes.
Does go on to say that the presidential order renaming the Jammu and Kashmir Constituent Assembly as the Legislative Assembly to get around 374 correct. Is not correct.
Correct.
But then goes on to say that the decision itself to abrogate,
that's a little jump.
Is so they've done a legal sleight of hand.
That's a little jump. Yes, quite right. It's a legal sleight of hand, which you are quite right. I disagree with that. That's apart from that. But therefore, what is the consequence? I mean,
yes.
Suppose I am right. Can Article 370 not be removed? It can. But it has to be done in the procedure mentioned in 368. That's my point.
So you're very clear that Article 370 is a temporary provision.
Yes.
So this belief that it was, there's a permanence to it, you disagree with that.
That's right, it says so.
But if you have to remove it, there is a process to be followed.
That's right.
In your view, there is a question mark over whether the process that was followed by renaming the Constituent Assembly as Legislative Assembly is the right process.
That's right.
So in your view, what would have been the right process?
Only go under 368, that is to say, amendment, which they haven't done. There's no amendment of the Constitution to get rid of 368. They've gone by presidential power. And presidential power only under 370. Once again, 370 clause 3.
And a constitutional amendment would have necessarily required a 2/3 majority
Yes, but that's
in
usually,
both
that's
houses.
the politics of it.
Yes.
Whether they would have got the 2/3, they would not have got it, is, to my mind, not of any significance at all. I mean, we are dealing with a constitutional question, so please let us decide it in accordance with the provisions of the Constitution.
Okay.
Whether it was